Okay, so what I'm going to do is to just set out the sort of basic framework of what it is that we're looking at when we're looking at priority need, and in particular what we're looking at in terms of vulnerability. And once I've done that, hopefully that will mean that when the other speakers put their piece in, you've got somewhere to sort of slot that information into, and you can see how it all ties together. And most of you are not lawyers, so I'm not going to be discussing any of the sort of finer appeal points or the dark arts of legal advocacy. That's not really what you're interested in, and I don't think it's really what will be helpful for you. But what I hope that you will get out of it is what the test is, so what it is that we should be looking at, and explain to you then what that means in terms of the evidence that you should be getting and how you can approach it. Okay, so the test under section 189 is concerned with priority need. So you can see that a person has a priority need if they are vulnerable as a result of old age, mental illness, or handicap, obviously really poor old-fashioned language, or physical disability, or some other special reason. And this test of whether or not a person is vulnerable, whether or not they have priority need, applies at two different stages. So it applies first of all at the interim accommodation stage. And at that point, we're looking at whether or not there is reason to believe that a person may have a priority need. And then subsequently, it applies at the point of whether or not the main homeless duty is owed to a person. And that's different. That's looking at whether or not the local authority is satisfied that a person is in priority need. So apparent priority needs, this is when you first apply to the local authority and you want them to provide accommodation. And this is the point where we get a lot of gatekeeping. And as I've already indicated, this is a low threshold, so reason to believe that an applicant may have a priority need. And the case law is really, really clear. You shouldn't really be making inquiries at that point. That's not the point that you make inquiries at. If a person goes to a local authority and they say, I have severe depression, well, then they have reason to believe that person may be in priority need. If a person is visibly anxious at the point that they apply for homeless accommodation, if a person struggles to speak, for example, all of those things are the sorts of things that might lead a local authority to have reason to believe that that person may have priority need. As I say, we're not making inquiries at that point. That's just purely on the things that are said and the things that a local authority officer has before them. So the key case on priority need and key case on vulnerability is Hotak and Southwark. And this really turns the law on its head. It's for a long time we had talked about coping with homelessness, and that was the test in the case of Pereira, which you will have seen in all the old decisions if you've been in this area for that long. But Hotak changed everything. And one of the things that it was really critical, that the Supreme Court was really critical of, was the way that the law had become sort of too technical. It started to focus on the words in case law as if that was the statute, as if that was the law that Parliament had set out. And the Supreme Court were really critical of this. So when we're looking at vulnerability, the very first thing that we should be asking is, are they vulnerable? Just what the actual words of the actual law, are they vulnerable? Without any gloss, without thinking about anything technical, ask that question first. And if the answer to that question is obvious, you probably don't really need to go any further than that. But, lawyers being the way that lawyers are, of course, it does get more complicated than that. But I wanted to start off with the basic proposition. So this is what a local authority should be looking at and considering when it's deciding whether or not a person is vulnerable. So first of all, it has to be assessed by reference to his situation if and when homeless. And it's a contextual and practical assessment of his physical and mental ability if he is rendered homeless. So because it is a contextual and practical assessment, it means that we need to think of it with, imagine the situation. If you're trying to persuade a local authority that a person is vulnerable, try to project forward, how will this person cope when they are homeless? What facilities will be available for them? Where will they eat? Where will they sleep? Can they sleep on a park bench? All of those sorts of questions are the sorts of questions that you should be asking, and really work through it with a fine-tooth comb. Try to be imaginative about how it would actually be and try to be as detailed as possible. And when we're looking at, when we say homeless, in this context, we're talking about a person that doesn't have accommodation, so doesn't have any accommodation at all. The Supreme Court was really critical of using the word street homeless, because again, it was sort of creating a kind of jargon that didn't need to be there. But really, that's what we're talking about. We're talking about a person who doesn't have a roof over their head. And it's important to bear this in mind, because an answer that you sometimes get from local authorities is, well, it's okay because they could get accommodation. Well, that's not actually that logical, because actually we're looking at them without accommodation. So there's no point in saying, well, they wouldn't be vulnerable if they didn't have accommodation, because they would have accommodation. It's completely nonsensical. So you have to imagine the situation of, this is a person who doesn't have accommodation. And going back to the what we saw on the previous slide, so it's a contextual and practical assessment. And this part of the decision in Hotak reinforces the earlier decision of Osmani and Camden. This is relevant for today, because in that case, one of the things that the court said, it was Lord Justice Old, said that you have to think about the debilitating effects of mental health conditions, and in that case, depressive disorders, and what would happen to that person's depressive disorder if they were deprived of the prop of their home. So without the home, without the security of a home and the safety of a home, what would that do to a person's mental health? And that then leads you to ask further questions. So what would happen to their mental health? What would happen to their physical health? So again, we're looking at this in quite a specific way. So looking at the particular characteristics of that particular person, and you're adding all of these things up together. And one of the reasons why it's important to think about the way that different issues interact, particularly in the context of trauma, is where you have mental and physical health concerns that are going alongside one another and that are affecting one another, because your mental health is not discrete from your physical health. The person who has depression, for example, may well find that if their depression deteriorates, they also find it less easy to manage their diabetes, for example. And there are lots of these connections, and particularly in relation to things like substance misuse. So a person whose mental health deteriorates, who then suffers a relapse in relation to their substance misuse. And that then creates further effects in terms of self-neglect, not eating properly, and all of those sorts of things. So that's why you have to have this holistic picture. So what do we do in terms of getting that evidence? Well, first of all, we need, obviously there's medical evidence. That's one thing that you can do. You can get your medical records, you can get those relatively easily, and it shouldn't cost you any money. If you can get a report. you may not be able to get that. You may not have the resources to get that. You may not have the time to get that. But if that is possible, if you have a treating professional, then that is something that you can do. You can get letters in support from professionals that are involved with you. One thing that is always very effective is if you can get a council worker in another area to write in your favour. So, for example, you might have a health visitor, you might have a social worker who is extremely cross about the way that you're being treated by the very same local authority, and that's always quite persuasive. One thing that I think is really helpful but is often dismissed by local authorities are benefits decisions. If you're receiving PIPs, if you're receiving ESA, then there will have been a decision about the difficulties that you have. And especially if that's gone to a tribunal and a judge has made those findings, those sorts of decisions should not be being glibly dismissed by local authorities. They are considered findings which go to a person's ability to function, and they are highly relevant to the decision of whether or not whether or not the applicant is vulnerable. But the other thing that I would say, which is very helpful, is extrapolating from past experience. So if the applicant has previously experienced a severe deterioration in their mental health because, for example, they were evicted from a previous home, or because they had a relationship breakdown, or because of some other sort of triggering event, then actually it makes sense to say, well, this is also a triggering event, and this is what happened last time. So we can extrapolate from that this is the sort of reaction that might happen in a state of homelessness next time. In terms of vulnerability, one of the things that the Supreme Court was quite clear about is that vulnerability can't be looked at in isolation. It's a comparative exercise that is being carried out. So the question is whether or not the applicant is more vulnerable than many others in that situation. And it connotes significantly more vulnerable than ordinarily vulnerable. Now, this is something which is relied upon a lot by local authorities, particularly the point about anyone who is homeless is vulnerable. But what does it actually mean? Who, in fact, is the local authority officer comparing the applicant to? I mean, of course, it's obvious that anyone who is made homeless is vulnerable, but that's why you have to start with the applicant's circumstances now, and then project forward to how it would be if they were without accommodation. The person who is already more vulnerable than the ordinary person is quite obviously going to be more vulnerable when they are without accommodation. And so what shouldn't happen is that, and does happen very often, is that the homeless applicant's circumstances now are compared with a person who is by that point already homeless. Well, that's not the comparison that should be being carried out. And I referred earlier to the ordinary person if made homeless. Well, this is really, really important. And it perhaps seems like a really obvious point to talk about the ordinary person, but it makes sense when you understand the case that was before the Supreme Court. So this reference to the ordinary person, it concerned the case of Mr. Johnson. So Mr. Johnson was one of the cases that was linked to Mr. Hotak's case when it got to the Supreme Court. And Mr. Johnson had mental health problems, suicidal ideation, and substance abuse issues. And the local authority had decided that these problems were very common amongst the homeless population, and he was not therefore unusual. And because he was not unusual, he was not vulnerable. Now you can imagine how this leads to a race to the bottom, a sort of vicious cycle. Vulnerable people get rejected for homelessness support and accommodation. So the street homeless population becomes more and more vulnerable and has more and more problems. And new applicants then find it harder and harder to show that by comparison, they are more vulnerable than that homeless population, which is getting worse and worse in terms of its ability to cope. So it was really important in that context that the Supreme Court confirmed that the comparison is not with the ordinary homeless person, but with the ordinary person made homeless. So who is the ordinary person? Well, if you look at all the old case law, there's all this talk, you probably heard the phrase, the man on the Clapham omnibus, the man who mows his lawn in his shirt sleeves and who washes his car on a Sunday morning. So there are all these old cases that talk about all of that stuff. And of course, it's terribly sexist because the ordinary person is never a woman. But anyway, the point is that the ordinary person is everyone and no one. They don't have any of these specific attributes that you are then presenting to the local authority. Now, it's important to bear that in mind because there's a bit of psychology that goes on here, which is that local authority housing officers are dealing with a very specific section of the population. And they're dealing with a lot of applicants for homelessness support who do have substance abuse issues, who are care leavers, who are abuse survivors or refugees. And it may well be that for them, in the context of the homelessness officer, these problems really are ordinary. This really is the ordinary person. But of course, those are not the attributes of the ordinary person. In fact, they're very, very far from being the attributes of the ordinary person. Those that apply as homeless are self-selecting, and obviously they are more likely to need that support. So that comparison is really important to bear in mind. Now, naturally, we all got very confused after HOTAC, even though the Supreme Court tried to make it very, very simple. But the Court of Appeal had to look at it again. So we had the case of Panellists and Waltham Forest. And that perhaps slightly finessed this test. So when the Supreme Court had said significantly more vulnerable than ordinarily vulnerable, what did that actually mean? And really the Court of Appeal said, well, it's qualitative, it's not quantitative. So it's not about having being more at risk in that way, but it has to be a sort of an appreciable difference. But I wanted to say something about what harm means. What does suffering harm mean? And it's really important in the context of what we're talking about today in trauma, because harm can be internal. The person who suffers an increase in intrusive thoughts, who has more rumination, more fatigue, more hallucinations or voices, these are harms. Suicidal ideation is a harm in itself. It doesn't necessarily have to result in active suicidal action. It can also be the thought itself can be a sort of harm which would be suffered by the applicant, but not by somebody else. And of course, those harms also then create further harms: self-neglect, inadequate eating, poor choices, risky behaviours, relapse in substance misuse. This case here of Wiest and the London Borough of Lambeth is and this extract in particular is incredibly useful. And of all the things that I'm saying today, this is the one that I would want you to sort of commit to memory, because it's very, very helpful. And this concerns an applicant with hypoparathyroidism, and essentially what the Court of Appeal said is, well, you have to compare the applicant with somebody who doesn't have that condition. So. And this is the point that I was getting at earlier, but it's said so clearly in this case. So if you have an applicant who has depression, well, you compare them with someone who doesn't have depression. If you have a person who has schizophrenia, you compare them with someone who doesn't have schizophrenia. If you have a person who has emotionally unstable personality disorder, then you compare them with someone who doesn't have that. And it makes it really simple, and it really shows up the vulnerability. It sort of brings to light the difficulties that that person has. So dealing with medical evidence, Schaller and Birmingham City Council is the sort of the key case. So that basically says that you shouldn't, first of all, it's a decision for the local authority to make, not for their medical advisors to make. And secondly, if you are comparing, for example, the opinion of a psychiatrist with the opinion of a GP, well, they shouldn't be given equal weight. But equally, you should take into account that when the local authority goes to now medical, for example, that's a person who hasn't seen the applicant. And so again, even if it's a psychiatrist at now medical, that opinion shouldn't be given the same weight as, for example, a treating professional. So that's this sort of basic point. But I want to give you a couple of examples of how that's been applied. And Thomas and Lambeth is not a case which is authoritative at all. It's only in the county court, but I think it demonstrates some really good points. Now, this was a case of that His Honour Judge Parfitt did, and if I read you an extract from the Now Medical report, I think it will contain quite a lot of words that you are very familiar with. So it says here, the issues are depression. The applicant has a history of depression, and I note has a history of suicidal thoughts and acts in deliberate self-harm. She's been treated with sertraline 50 micrograms, I would imagine, the standard antidepressant in low dose, and has been referred for counselling, which would be considered standard treatment. There is nothing to suggest that she has required urgent psychiatric intervention, and there is no evidence in this case of a severe or enduring underlying mental illness that would significantly affect her cognition or rational thought. Whilst I note that she has suicidal thoughts, there is no evidence of significant concerns regarding intent in this case. So those words of a severe or enduring mental illness that significantly affects her cognition or rational thought, we will all have heard those words. They're cut and pasted. And if you ever want to do any analysis of the fees that Now Medical charge local authorities, and you can compare them with their accounts, which are publicly available, you can pretty much calculate that I think I worked out about 7 minutes per report. So that gives you a bit of an idea of why there is so much cut and pasting that happens in Now Medical's reports. Anyway, His Honour Judge Parfitt thought that this was absolutely dreadful and completely useless, really. And what he said was that, first of all, the problem here was that it wasn't for Now Medical to answer the question of whether the applicant was significantly more vulnerable than an ordinary person. That is not the doctor's expertise. The doctor is there to give an insight into a person's medical condition and mental health. It's not to make the decision for them. And they shouldn't be giving their opinion on things which are outside of their expertise. You will see this all the time, however. But the second point, which I think is really useful, is that His Honour Judge Parfitt said, it is unhelpful for these reports to identify problems that the appellant is not alleged to be suffering from. Here, a condition requiring urgent psychiatric intervention and/or a condition which would significantly impair her capacity, and then reach a conclusion based on the absence of those factors. I mean, it's absolutely right. And I mean, he goes on a bit more length about exactly what the problem is. The point is, there is no point in saying, well, and again, you see this all the time, oh, this person can dress themselves. This person, I mean, it's a bit like saying this person doesn't have a missing leg. I mean, well, if that's not what you're alleging, where does that take you? How does that help us to understand what a person's mental health is like? If a person is saying, I have depression, well, that's what needs to be considered, the effect of the depression. No point in saying that they don't have schizophrenia or they don't have hallucinations or any of those things. That doesn't take anyone anywhere. Greece we've already looked at, but that's also a very useful one in terms of the weight that should be attached to different medical opinions. Just one final thing on this case of Perrott and Hackney. Again, not an authoritative case, but a good example of applying the case of Greece, again in the context of a now medical report. So in this case, Mr. Perrott's vulnerability arose from gastrointestinal problems. And after receiving the homelessness application, Hackney, of course, obtained a report from Now Medical, which found that his conditions were not particularly more significant than those of an ordinary person. When Mr. Perrott applied as homeless to Hackney again in December 2019, it was again decided that he was not vulnerable based upon the previous report from June 2019. As part of his review submissions, Mr. Perrott provided Hackney with a questionnaire prepared by his GP, which stated that he suffered from debilitating pain. And this is a good example of something that you can do, is to provide a questionnaire to a GP. And it stated that he suffered from debilitating pain and he needed good hygiene and access to bathing facilities to avoid infections. Now, the review officer upheld the decision, stating that she had given equal weight to both the Now Medical assessment and the report from Mr. Perrott's GP. His Honour Judge Roberts thought that this was rubbish, basically. How on earth could the report of Now Medical possibly be of equal weight to the GP that had met with Mr. Perrott and who understood what his condition was? And so this was a complete error of law. It was completely irrational, and of course the decision had to be quashed. Unusually, not only was the decision quashed, but the judge found that the only possible rational decision was that Mr. Perrott was vulnerable and was in priority need. So hopefully that gives you an idea of the sort of things that you're looking at, the sort of evidence that you might get hold of, and how a local authority should be treating it once it has that sort of evidence.